And in what ways does the finished document really influence the judge at sentencing?
Well, it is the first document that the court sees prior to sentencing that contains information about the defendant. So it really does have an influence. Now, I pride myself on making very compelling arguments at sentencing, so I like to say that the probation report really doesn't have that much impact, but I may be in denial. I think that it's certainly a very important document, again, because it's the first thing that the judge sees, but it is something that I almost regularly disregard as far as its recommendation if I disagree with it, because it really hammers on the sentencing guidelines. And I don't like the guidelines. There are a lot of judges who don't like the guidelines. I want the judge to do what's right. I don't want the judge to be following just a chart when they're sentencing my client, who's a human being.
So you'd mentioned that the probation officer puts a lot of information in there about the defendant's past. Why don't you tell us what a defendant can do proactively to influence the outcome of that pre-sentence investigation report?
So this is really the most important part of the case, in my opinion. Preparing for the pre-sentence report is an opportunity to have your version of your life and the conduct, the offense conduct, integrated into the PSR. So the first thing that the judge sees is actually your side of the story, not the government's, not the discovery from the case or the FBI reports or whichever agency is involved, but your side of the story. And right from the start, we can start to build a sense of compassion and sympathy and empathy for the client in the judge's eyes. So what I generally do is I have my client prepare a letter that first and foremost contains a very sincere statement of remorse, which is one of the most important things that the judge wants to see. But then also I have them really go into detail. And oftentimes this requires some very deep soul searching. It can be very emotional for some people, but it has a tremendous impact on the outcome. And the more detailed the letter is, the more detailed the information is about their remorse, about their history, about what led them into the offense conduct, if there is drug addiction, if there is mental instability, if there is a horrible, tragic family history, which is most often the case, if there is some sort of abuse. These are all of the things that I want in the letter so that the probation officer essentially can cut and paste from my client's letter and put it into the probation report so it becomes something that we have much more control over. And what I have found is that when we go to the pre-sentence interview with the probation officer, they're very appreciative that we've provided them with all of this information before we've even started. And then if they have follow-up questions, they can dig more deeply into these areas and sometimes end up providing even more mitigation just from where we've presented this information.
So many of the defendants that I've worked with in the past really lack that level of ability to introspect and express it because they're still living in a state of denial, and a lot of times they are reluctant to provide that type of detail. In what ways can you work with a defendant who doesn't quite know how to provide that level of detail that you're looking for about his background, about what led him into the offense, about really accepting responsibility? In what ways can you work with a defendant who is really just not in a frame of mind? His life's spinning out of control. He's afraid of losing his family, his business, his reputation. What can you do with that type of defendant?
Well, most often, Michael, I send them to you. And I have had extraordinary experience with my clients who have come to you, and you spend hours with these people. And you just seem to have this way of not only writing the narrative beautifully, but getting the person to dig down deep and to accept what's happening to them because you've been there. And this is a perspective that is extraordinarily rare, and it's something I certainly can't provide my clients. And you have this magic touch, I may say, an ability to get people to really express everything that's important. And every letter that I've written every letter that I've read that you've assisted my clients in writing has been tremendous. We've had tremendous results. We've had that reaction from probation where they have been appreciative of the work and also visibly moved. I have seen just recently, last week, a probation officer had tears in her eyes because she was familiar with my client's background, everything he was going through, the steps that he was taking to show his remorse. And I have known this particular probation officer for almost 20 years, and I've never seen her move to tears. So that was quite extraordinary.
You know, to be truthful, whenever that happens, it's really the defendant's words that are coming out. It's just a matter of questioning and getting and asking questions so that the defendant is really revealing that remorse and how he or she is identifying with the victims and starting to see. Just really the idea, I think, in that narrative is for the defendant to be able to help those who are reading about him see that person as a human being and a common humanity. And although not explain away what happened or excuse what happened, but really just talk about how did I get here. And I do think that you provide your clients with a great service when you help them recognize this is perhaps the biggest sale they are making in their life, where they're having to show a judge and others stakeholders why they're different, why they are something more than simply the criminal charge. But my next question, Diane, has to do with how the PSR influences other stages of the process. Could you tell our audience how whether the pre-sentence investigation report can have some type of influence on an earlier release even after sentencing?
Yes, so there is a program in the Bureau of Prisons called RDAP, which is a 500-hour drug treatment program, and it applies to people who have alcohol or drug issues. If their substance abuse is accurately reflected in the probation report, then the judge at sentencing can recommend to the Bureau of Prisons that the defendant participate in the 500-hour drug treatment program. As a result of their participation in this program, they can get as much as a year off of their sentence. Aside from that, which is an extraordinary benefit, I have heard that it is an excellent, excellent program, and people who have done the program have great success in staying clean and sober. So it's a great program, but it also, a year off of your sentence is extraordinary.
Well, thank you very much for sharing your wisdom on the federal sentencing guidelines, in particular the pre-sentence investigation report. We've been listening and learning from Diane Bass, a premier Orange County criminal defense attorney that has a real specialty practice in preparing individuals for sentencing. And you gave us some really extraordinary statistics, Diane. How many of the people who are charged in federal court will eventually have a sentencing hearing?
About 90%.
About 90%, and that's why it makes sense to contact Diane Bass if you are facing a sentencing hearing anywhere in the country in federal court. Her contact information is above, and I hope that you will have the best possible experience if you're facing charges in the federal criminal justice system. That's it for today with Earning Freedom. We'll be back soon with another inspiring message or message that you can use as you prepare to navigate the challenges of the criminal justice system. Thank you.
Thank you.